everybody, we're back. Sorry about that. But yeah, that lobby just all of a sudden everybody wanted to come in and have a meeting. So I'm back. You guys come on in, come on in. Please like, share. This is gonna be part two. Subscribe if you haven't done so already. Good evening, Linda. That's fine. Thank you for your support. Hey, hey, hey to everyone. We're back. We're back. We're back. Yes, we're back. Thank you to all the mods that came back and that are here. And hopefully everybody comes back in. But before I had to change locations, I was talking about the XXX Tentacion trial. Many people probably don't know who he is because I didn't, or maybe it's just me. But his trial started today, and it was very interesting because it was streamed online. So on a couple of the days, I may actually stream it on the platform so that we can watch it together. But today they had opening statements, and I didn't know what happened, so I learned what happened today during the opening statements, according to the prosecution's perspective. And essentially, what they were saying was that four men rented a car from Toro, and allegedly their purpose of renting the car was so that they can rob people that day. And X, I'm just gonna call him X because he has the long name. His real name is like Jasian or something like that. But he decided he wanted to buy motorbikes that day with cash. So he goes to the bank. It was a Bank of America. And it was crazy because they actually showed the video of him in Bank of America and just him kind of chit chatting with the teller because that's where he banks all the time. And he wanted $250,000 in cash. So y'all already know that typically they have to order that money. So they don't have that type of money on hand. So she had to get her manager and everything. And he ended up getting 50,000. So they show him putting the 50,000 in his Louis Vuitton fanny pack, throws it over, goes out. So apparently he had talked to his mother that day, and his mother told him she didn't want him going places by himself. She wanted him to start bringing people with him. So the mom, whose name is Cleopatra, got like a step uncle. It's like the uncle to X's younger brother or something, and says, hey, and he's like from Jamaica, asked him to come and to go with him to get the bikes because she didn't want him to be by himself. And it was basically these beefs that are online between, I think they said Drake and I think they said the Migos. So it was like two different groups. So the mom, I guess, is supposed to testify. She hasn't testified yet, but she's supposed to testify that she wanted him to go with somebody because of these beefs online. And so she calls this guy who comes, who is the uncle, the step uncle, and she drops him off at the bank so he can get in the car with X, who drives a BMW with the butterfly doors. They get in the car. They go to the motor place, and he has on his jewelry. He has the expensive car. He has all of that. So he goes in and he's about to buy these motorbikes because they were saying plural. So apparently at the same time, it was these four guys and they're riding around. They got this car and their whole purpose is to rob people. So they pull up, and I guess one of the guys has been to that bike shop before. So two of them comes in, they buy masks and everything. They allegedly are noticing X and they're looking at his stuff or whatnot. So they leave out. According to the prosecution, it was communication between the two that went in and the ones in the car. And they go out or whatever. They leave out. They kind of look around in the place. The two of the alleged robbers leave out of the bike place, and they get in the car. And I guess when X leaves, because he doesn't buy any bike, he leaves out and gets into his car with his step uncle. They try to exit, and then this car the car they got off Turo, blocked them in, and so they got robbed. And we all know what ended up happening. That was his demise. He ended up being unalive. So the people that testified was the bank teller. So they were able to show like his final moments almost, because it was like within the hour he ended up passing. And so they showed like him walking up, and I seen people had those videos today. It was real eerie because it's like he was just cheery and happy and talking to the teller and just real innocent looking in the face. It was like wow. And so it was a long, and then the prosecution made sure they made it real long and drawn out because they wanted that effect that it gave us that we're watching like, dang, that's messed up. He had no clue that was gonna be it. So the defense comes back, and Boatright, it's a guy named Boatright who was there, and he's supposed to be the guy that they say pulled the trigger. The defense basically said he wasn't there. He was at his grandmother's house. That was in their opening. He was at his grandmother's house, but he tried to explain away him being in certain videos. So he wasn't in the video at the motor place, like the place that they bought the vehicle, I'm sorry, that he was trying to buy the bikes from, but he was later on caught on video being in the car. Then it was like his attorney was kind of trying to explain away how they were able to see pings on the cell phone. Then allegedly all these guys get on social media after the fact and they showing money, that they came into all this money or whatever. Then one of the phones had where they were searching X's name in the phone. Then one of them had something about searching for conspiracy and all of that. But all of them was pretty much saying it wasn't them. They had masks on. Nobody knows who really was. And then, of course, we had the one, because it's three defendants being tried at the same time. So it's like Boatright, Williams, and I think his name, what's Newsome? Think it was Newsome. But then the fourth one, he turned state's witness. So he's the one that's really identifying everyone. So of course they were saying he's changed his story. He's just trying not to. So the one that's actually turned state's witness, his face was caught on camera. So I guess he didn't have much of a choice. So he pled guilty to murder, but he has the chance of getting out. The rest of them, they're on trial, of course, for probably without the possibility of parole, like felony murder, because it was a robbery. So yeah, so that was the first day. So I'll probably be following that trial. It's very interesting. I wish I had did the opening with you guys earlier, but I was in between. I had my own hearing today, so I was kind of in between watching that and then watching the hearing. But yeah, the defense attorney for Boatright, Michael Boatright, I don't know. I wasn't that impressed. There's a Dedrick Williams. He's the one that basically said about how Drake, it's supposed to be some beef with Drake, and how they were tunnel vision. The DA and the police were tunnel vision when they knew that there was a beef with Drake, but they never mentioned they never tried to interview Drake. It was another rapper, I guess he was allegedly beefing with. They never interviewed him. So that's kind of their theory, because all these people had masks. So they're almost using it by the way they look, like one's tall, one's short. Pay attention to their body type. Look at how they look now. But it sounds like a lot of their testimony, a lot of the state's cases is going to hinge on this state's witness that was with them. So it was originally 4, but now it's down to 3 that's in trial. But it's very interesting. Very interesting. Yes, please, please, please. So, and then, we're going to go over our documents today on Bishop Whitehead. You guessed it. I told you guys that there has been, and this is pertaining to the U.S.A. versus Whitehead. So this is his case that he was indicted in. So I told you guys that his attorney, and we know who his attorney is, has filed a bunch of motions. Well, one of the motions that he filed, the government responded to a little bit earlier this week, I believe, but then there was some correspondence today. So let's go over, and I'm not going to read all of his attorneys, like what the motion was, but you guys should be able to get the gist of it because it's just way too long for no reason, in my opinion. But let's see. So essentially, they filed a defendant's notice of violation of local criminal rule 23.1 by U.S. Attorney Damian Williams, FBI Assistant Director Michael J. Driscoll, and government agent Brandon Belmonte. Now, we know Brandon Belmonte is victim number 2 as alleged in the indictment. So he says, please take notice that the following persons released or authorized the release of non public information or opinion, which was disseminated by means of public communication in connection with this pending litigation that created a substantial likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. So he lists those individuals, the U.S. attorney, the FBI agent, and then the actual one of the victim number 2. So the issues he's saying before the court is whether U.S. Attorney Williams is a lawyer subject to the local criminal rules 23.1, whether the FBI Assistant Director Jay Driscoll is a government agent or police officer under local rule 23.1, whether Mr. Belmonte is a government agent under local criminal rule 23.1, and whether U.S. Attorney Williams released or authorized the release of non-public information or opinion which was disseminated by means of public communication in connection with pending litigation. We have a whole bunch of. So this is what Criminal Rule 23.1 provides. If it is the duty of the lawyer or law firm and of non-lawyer personnel employed by a lawyer's office or subject to a lawyer's supervision, private investigators acting under the supervision of a criminal defense lawyer and government agents and police officers not to release or authorize the release of non-public information or opinion which a reasonable person would expect to be disseminated by means of public communication in connection with pending or imminent criminal litigation with which they are associated. If there is a substantial likelihood that such dissemination will interfere with the fair trial or otherwise prejudice the due administration of justice. So then he goes on with some more of the rule. So what he's asserting is defendant Lamore Whitehead, who should be referenced as defendant or Bishop Whitehead, asserts the following. U.S. Attorney Williams is a lawyer under local criminal rule 23.1 of the Federal Rules of Criminal Procedure, provides in pertinent part the following definition applies to these rules. Attorneys for the U.S. government means a United States attorney or an authorized assistant. Attorney Williams signed the indictment that is charging instrument in this case. FBI Assistant Director Driscoll is a government agent. Police officer under local rule 23.1. The FBI was established as an agency of the government on or about July 26, 1908. It follows that its employees are government agents. So then he says Mr. Belmonte is a government agent subject to local criminal rule 23.1. Most generally, a government will be somebody acting in an official capacity on behalf of the federal government. According to Jenna Solari, a senior instructor in the Federal Law Enforcement Training Center's legal division. So this is what he's saying happened, to get to the gist of it on why he filed this. And he filed this after that article we read, that long article that talked about the sister and gave the name of the victim, the alleged victim number 2. So U.S. Attorney Williams released or authorized the release of non-public information or opinion which was disseminated by means of public communication in connection with this pending litigation. On Monday, December 19, 2022, U.S. Attorney Williams released or authorized the release of a press release on his website. So they're talking about, remember when the indictment came out, they announced it on the website, which they typically do with most defendants. But he's saying that the statements violated this rule somehow. So he says the text in the press release states Damian Williams, the United States Attorney for the Southern District of New York, and Michael J. Driscoll, Assistant Director in charge of the New York Field Office of the Federal Bureau of Investigation, announced accordingly, U.S. Attorney Williams released or authorized the release of the opinion noted herein. FBI Assistant Director Driscoll released or authorized the release of non-public information or opinion which was disseminated by means of public communication in connection with this pending litigation. On Monday, December 19th, U.S. Attorney Williams released or authorized the release of a press release. And he says the same thing. The text in the press release states Damian Williams, the United States Attorney for the Southern District of New York, and Michael J. Driscoll, Assistant Director in charge of the New York Field Office of the Federal Bureau of Investigation, announced accordingly the FBI released and authorized the release of the opinion. Mr. Belmonte released or authorized the release of non-public information or opinion which was disseminated by means of public communication in connection with the pending litigation. Mr. Belmonte is directly quoted in an article written by Eric Latch in the New Yorker that was published on or about January 14, 2023. He gives the site. Mr. Belmonte's quotes contain non-public information and or opinion which is written below about this pending litigation. The non-public information or opinion released or authorized to be released by U.S. Attorney Williams created a substantial likelihood that such dissemination will interfere with a fair trial or otherwise prejudice the due administration of justice. U.S. Attorney Williams, in his press release on Monday, December 19th, stated, as we allege today, Lamar Whitehead abused the trust placed in him by a parishioner, bullied a businessman for $5,000, then tried to defraud him of far more than that and lied to federal agents. His campaign of fraud and deceit stops now. This opinion is impermissible under and a violation of the local criminal rule. Namely, the opinions of abused trust and bullied are not in the indictment. These opinions are presumptive 23.1 violations as per local criminal rule 23.1. The court may order U.S. Attorney Williams to remove the above-mentioned comments that are currently posted on his website in the form of a press release. So then it has the case law. Notwithstanding the foregoing, if the court does not direct the removal by its own motion under local criminal rules, defendant intends to move for such relief under Rule 23.1. Attached to Exhibit A is a true and correct copy of the subject press release. Let me go down. I'm trying to see what quotes he's trying to say was improper. Y'all. So on Monday, December 19th, he's saying this is to the Driscoll. This is to the FBI Assistant Director. He said, as we allege today, Whitehead carried out several duplicative schemes in order to receive funds from his victims. Additionally, when speaking with authorities, Whitehead consciously chose to mislead and lie to them. If you are willing to attempt to attain funds through false promises or threats, the FBI will ensure that you are made to face the consequences for your actions in our criminal justice system. The consciously opinion stated is not in the indictment. Bishop Whitehead's conscious or intent is not alleged in the indictment as opined. Further, that ominous statement that the FBI will ensure that you are made to face the consequences for your actions in our criminal justice system violates Rule 23.1. These opinions are presumptive 23.1 violations as per local criminal rules. The court may order FBI Assistant Director Driscoll to remove the above mentioned comments that are currently posted on his website in the form of a press release. So he kind of says the same thing. Then he says the non-public information or opinion released or authorized to be released by Mr. Belmonte created a substantial likelihood that such dissemination will interfere with a fair trial, otherwise prejudice the due administration of justice in this case. Mr. Belmonte released a series of statements to the New Yorker journalist Eric Latch, who published a Dunning article on defendant and this litigation on January 14, 2023, online and upon information and belief in print in the New Yorker. As of December 2019, the New Yorker reportedly had print circulation of over 1 million copies. Most importantly, the New Yorker also disseminated the subject article on their internet website, which is available in the Southern District of New York. And they attached the article. Bishop Whitehead alleges that Mr. Belmonte's statements made in the article violate 23.1's prohibition against the release of opinion and non-public information by government agents that interfere with a fair trial or otherwise prejudice the due administration of justice. According to the court, made by its own motion, issue a special order pursuant to local rule 23.1, prohibiting Mr. Belmonte from making statements to the press in violation of local criminal rule 23.1. Mr. Belmonte's statements to Eric Latch and the New Yorker violated local criminal rule 23.1. His statements clearly prejudiced the due administration of justice and potentially interfere with a fair trial. Mr. Belmonte violated local criminal by identifying a prospective government witness. Didn't you file a lawsuit, though, in civil court? Whether or not the government will use that witness is not the issue. Local Criminal Rule 23.1d4 prohibits the release of the identity, testimony, or credibility of prospective witnesses. Mr. Belmonte additionally gives his opinion as to the accused's guilt and as the merits of the case or the evidence in the case, which is clearly prohibited by local criminal rule 23.1 and presumptively violative of the rule as per local criminal rule. So he puts the quotes from the New Yorker from Mr. Belmonte, quote, he basically says, you got to give me another $5,000, end quote. Quote, I said, bro, the job was only 25,000, 13 and 5 is 18. The parts were $7,000. I'm going to make zero, end quote. Quote, I got City Hall in my back pocket, end quote. Mr. Belmonte said Bishop Whitehead said this. Quote, Eric's doing big things, end quote. Mr. Belmonte said Bishop Whitehead said this. Quote, I got to get mine, end quote. Mr. Belmonte said Bishop Whitehead said this. He said, quote, Eric Adams can make it a homeless shelter and you'll get city benefits, end quote. Quote, he kept telling me we're going to make millions together. And he said, you got to give me the $5,000 or I'm going to beat you up. I said, I think the mayor of New York is on the take. And he said, what do you mean? Belmonte is referring to he being the investigator at the U.S. Attorney's Office, according to the article by Mr. Latch. I said the mayor of New York City is trying to extort me through someone else. So yeah, so that that is pretty much the gist of the motion. And so the court ordered the government to respond to that. And of course, they did respond to that. So we're going to go over their response in just a few. So he's saying when the article came out and when the press release came out, it was in violation because they gave information that shouldn't have been given to the public, and now he just can't have a fair trial. So the government responded on February 4th because the court did order them to respond to these allegations in this motion. And and this is the government's response. On January 17th, Whitehead moved under Local Rule 23.1 of the Local Rules of the United States District Court for the Southern and Eastern District of New York for relief against Dedrick Williams, the U.S. Attorney for the district, Michael J. Driscoll, the Assistant Director of the FBI responsible for the New York field office, and Brandon Belmonte, a private person. The motions against the U.S. Attorney and Assistant Director Driscoll are meritless because their statements in the press release announcing Whitehead's indictment simply restates allegations in the indictment against Whitehead, and the motion against Belmonte fails at the threshold because Belmonte is a private citizen, not subject to Rule 23.1. So they restate the rule as well. The discussion, Whitehead claims that the U.S. Attorney released non-public information in the press release announcing the defendant's indictment and arrest. which is attached to his filings as an exhibit. The statement from the U.S. Attorney reads, as we allege today, Lamar Whitehead abused the trust placed in him by a parishioner, bullied a businessman for $5,000, then tried to defraud him of far more than that and lied to federal agents. His campaign of fraud and deceit stops now. So they attach that as an exhibit. According to Whitehead, the opinion of abuse, trust, and bully are not in the indictment, and therefore the statements discloses an opinion based on non-public information in violation of the local rule. So then they say, as an initial matter, there is nothing unusual about the U.S. Attorney issuing a press release announcing an arrest. And they have the case law related to that. And the specific comments here do not opine on the defendant's guilt because they are expressly prefaced with the phrase, as we allege, and are further accompanied by at least two other disclaimers. The charges contained in the indictment are merely accusations, and the defendant is presumed innocent unless and until proven guilty, and the entirety of the indictment and the description of the indictment set forth herein constitute only allegations, and every fact described should be treated as an allegation. So they have that as an exhibit, and they also have the case law, which stands for the proposition that finding no opinion on defendant's guilt in press release using similar language. The defendant correctly does not object to the bulk of the press release because it merely summarizes the indictment in this case and thus contains subjects expressly approved by Rule 23.1e, such as a description of the case. The U.S. Attorney's use of the word, quote, bullied and abused the trust does not convert that description into opinion. A public servant paraphrasing a formal legal indictment in a press release is permitted to use colloquial language. Courts have thus rejected attacks on the following phrases in U.S. Attorney press releases, describing a series of bank robberies as a spree and unprecedented, characterizing an attorney defendant as among those attorneys who use their law license as weapons and are acting as, quote, criminals, and describing a defendant politician as having quarterbacked an unappetizing smorgasbord of grafts and greed as part of a show me the money culture of corruption. So they're basically showing examples of how they use these type of words in order to describe their indictment. So they're paraphrasing by using certain terms, and they're putting the case law in here that justifies their ability to do so. Especially given those precedents, it is difficult to see how the U.S. Attorney gave any impermissible opinion by offering a straightforward restatement of the indictment's charge that Whitehead defrauded one of his parishioners as an abuse of trust, or the charge that Whitehead extorted a businessman as bullying him for money. Whitehead's attack on Assistant Director Driscoll's statement is similarly misplaced. Whitehead objects to the use of the word consciously in the sentence when speaking with authorities. Whitehead consciously chose to mislead and lie to them because he claims the consciously opinion stated is not in the indictment. But the indictment charges Whitehead with willfully having falsified, concealed, and covered up by a trick, scheme, and device a material fact, specifically telling FBI agents executing a search warrant that he had only one cell phone, even while using his second cell phone. Describing willful conduct as conscious is not merely a fair paraphrase, but part of its legal definition. So they put the case law, which it says affirming jury instructions defining willfully in part as requiring that defendant's actions must have been the product of her conscious objective. Even less colorable is Whitehead's complaint about the purportedly ominous statement that, quote, if you are willing to attempt to obtain funds through false promises or threats, the FBI will ensure that you are made to face the consequences for your actions in our criminal justice system. Investigating fraud and extortion is indisputably part of the FBI's mission. And law enforcement officers are entitled to, quote, speak about the facts of a case, the offenses charged, and even the public policy significance of a case, to the extent that such discussion is in furtherance of law enforcement. More case law to substantiate what their argument is. And they say that United States v. Silver stands for the proposition that of note, it is part of the role of the U.S. Attorney to make policies in connection with the administration of the U.S.A. There was nothing remotely inappropriate about Assistant Director Driscoll stating that the FBI would do its job. C. Avenatti. And then it has more case law. Inherent in every announcement of criminal charges is, of course, an implicit message that the prosecutor believes that the defendant is guilty. That implicit message does not violate a defendant's rights. So they have more case law in the footnote. With respect to Belmonte, Whitehead's arguments are equally flawed but fail at the threshold because Belmonte is not an agent of the government. Belmonte is a private citizen. In April and May 2021, Belmonte, who was described as victim 2 in the indictment, recorded certain meetings with Whitehead during which Whitehead engaged in the crimes charged in counts 2 and 3 by, for example, making veiled threats of physical violence if Belmonte did not pay Whitehead $5,000 and promising Belmonte that he could obtain favorable legal action and valuable contracts from the New York City government if Belmonte transferred money or real estate to Whitehead. Belmonte also cooperated with the FBI's investigation in other ways, such as by providing copies of text messages between Whitehead and Belmonte and consenting to being interviewed. But Belmonte is in no sense subject to the government's ongoing control. He does not even have a cooperation agreement with this office. Belmonte is thus not an agent of the government within any recognized meaning of the term. Perhaps needless to say, the government did not authorize Belmonte to participate in the media interview about which Whitehead complains, nor did he consult with the government before doing so. And it is unclear at best that the government could have done anything to prevent the interview had it known about it, given Belmonte's right under the First Amendment. Thus, to the extent Whitehead wishes to restrict Belmonte's public statements, he should seek relief against Belmonte, not the government. In the interest of avoiding unnecessary litigation, however, the government notes that it has provided a copy of Whitehead's filing on this issue to Belmonte's attorney, and those attorneys have informed the government that although they do not confirm that Belmonte has spoken with the media in the past, he has no intention of discussing this case with the media in the future. This court could therefore reasonably deny this portion of the motion on that ground alone. So then there was a motion. They're responding to all the motions that were filed. So then the second part was the defendant's motion for the identification of the witnesses and saying that they were premature. Defendant's Rule 12b-4 motion is without merit. So on January 19, 2023, Whitehead moved for an order compelling the government to disclose any and all evidence or information that it might offer at trial so that he could move to suppress that evidence and to identify any evidence or information that he might move to suppress, citing Federal Rules of Criminal Procedures 12b-4. Does not, however, entitle defendants to compel the government to provide an exhibit list as part of the Rule 16 disclosures or to point out which pieces of evidence the defendant might wish to move to suppress. Rule 12b-4b is a procedural device intended to facilitate efficient pretrial motion practice, U.S.V. Conyers. It thus does not impose an obligation on the government to identify for the defense potentially suppressible evidence, nor does it require the government to preview its case. Instead, the rule enables the defendant to identify a specific piece of evidence that he intends to move to suppress, at which point the government will inform the defendant whether it intends to offer that evidence at trial. The process conserves resources because if the government is not going to offer the evidence at trial, there's no need to litigate a motion targeting that evidence. Whitehead has not attempted to meet his obligation under Rule 12b-4, but has rather moved for a blanket exploration of any and all evidence to which the government suggests to him that motions he might wish to file, exactly as the case law discourages. Should Whitehead identify any particular evidence, he will seek to suppress. The government remains ready to fulfill its obligation under Rule 12b-4, but at present, it is clear that Whitehead filed this motion without performing even basic diligence. For example, Whitehead asserts that the government, quote, conducted wiretaps, end quote, in this case, but it did not. and there are thus no Title III orders which could form the subject of a suppression motion. Similarly, Whitehead's claim that his counsel, quote, has not found defendant's image or voice, end quote, on the recordings on discovery seems doubtful, given that he has repeatedly discussed the multiple video and audio recordings of his client and Belmonte. Oh, Jesus. So then there was another motion. The defendant's Rule 806 motion is premature and likely moot. On January 20th, 2023, Whitehead moved for material that could be used to impeach the out-of-court statements of Belmonte pursuant to Federal Rules 806. According to Whitehead, quote, the government most likely will seek to admit statements of Brandon Belmonte under Rule 801 D2D of the Federal Rules of Evidence. The government has informed Whitehead that it does not presently intend to call Belmonte as a witness or offer any of his statements pursuant to Rule 801 D2E or any other rule of evidence that will permit the jury to consider his statements for the truth of the matter asserted. Rule 806 therefore does not apply. If, contrary to the government's current expectation, it later determines that it intends to call Belmonte or rely upon any of his out-of-court statements for the truth of the matter asserted, it will disclose any impeachment material in its possession on whatever timeline is later set by the court. So that would be the response to all of the motions we talked about, but the main one that I wanted to discuss was the one against the statements that were made and the ones that were made allegedly in the magazine. So apparently there was a conversation that took place, a meeting conferred between the government and Whitehead's attorney today. And so after that conversation, Whitehead's attorney felt it necessary to file, basically memorialize that conversation with the government and to file it for us all to see. And so I'm going to read a portion of it so you guys can kind of see where he was going with this in his response, in his reply. Let me see. So as you see, it has today's date on it. So he says, as you know, I represent defendant Lamar Whitehead. This letter is in follow-up to our 20-minute call on today, Tuesday, February 7, 2023, at 12:30 p.m. During the call, we discussed issues concerning Bishop Whitehead's emergency motion for a special order pursuant to Local Criminal Rule 23.1H. The first issue we discussed is whether Brandon Belmonte is or was a government agent, subject to Local Rule 23.1. Defendant's position is that Belmonte was a government agent and is subject to Rule 23.1H. The government's position is that Belmonte is not a government agent subject to Rule 23.1. Further, the government concedes that he was a government agent during the investigation. However, the government is of the position at the time of Belmonte's release of the subject alleged non-public case information or opinion to the New Yorker for publication, Belmonte was not a government agent as he was no longer at the behest of the government on this case. Further, the government also takes the position that even though Belmonte was per se a government agent during the course of the investigation process, he is not a government agent for the purposes of Rule 23.1H. That position makes no sense and is not supported, I think he meant by authority. As a proposal for the integrity of this case, I asked the government to concede that Belmonte be ordered to comply with Rule 23.1H since he had access to non-public information in this case for reasons that remain unclear to me. The government would not agree to Rule 23.1H order. Next, we discussed the effects of Belmonte's dissemination of non-public case information or opinions to the New Yorker has made, including contact from citizens who are his alleged victims. So now he's getting into talking about Belmonte's and his alleged past, and now he's getting phone calls allegedly, I guess, from people that are saying they were victimized by Belmonte. Remember the clip we showed before when Whitehead and I showed you when he said, oh, and that other person in the indictment, people are already calling, talking about Bishop. We can't, that's what I'm assuming they're talking about. So the alleged victims emailed evidence of wire fraud and theft that has occurred in this district. Said alleged victims include a licensed attorney who says she was victimized by Belmonte. Being that she is an attorney, I provided her with your contact information and FBI crime link. Upon information and belief, she has made contact with your office prior to our call on today. During our conference call, you indicate that you can't respond to private citizens' complaints. However, I noted that you may direct such complaints to the proper channels for their attention. You also indicated that such alleged victims should contact the FBI to report suspected crimes. As you know, I indicated that it was my understanding that some did so already without success. Pursuant to our discussion, I asked if the government was aware of alleged crimes by Belmonte. You refused to discuss whether the government was aware of the alleged crimes of Belmonte. Further, when I noted that I would direct the people contacting me to your office, you indicated that such contact by them would be, quote, spam. You further indicated that such contact would be malicious. And finally, you indicated that by suggesting that I would direct them to your office was a threat. Quote, I took great offense to all of your mischaracterizations of our discussion. First, private citizens contacting your office to report alleged crimes concerning Belmonte, who you refused to agree to the court entering a special order against under Rule 23.1H, is not spam. Second, it is not malicious to tell an alleged victim of your former agent to contact your office. Third, it is not a threat for me to advise you that I will direct persons to you who contact me. Clearly, your office is public and can receive inquiries from citizens concerning alleged crimes. In light of your serious mischaracterizations in our call, I informed you that I would follow up the discussion with this letter to memorialize the call and dispel your mischaracterizations above. Per your request, I will direct citizens contacting my office as a result of Belmonte's article to, and he gives the link. Though they can contact any law enforcement, I trust that the government will take any citizen's complaint seriously and prosecute any crimes. Given that Belmonte, the government's former agent, has allegedly used the government and its agencies, including the FBI, as a sword for his alleged crimes, whoa, which mirrors the crimes alleged by the government in this case, the government turning a blind eye to the numerous serious alleged crimes by Belmonte, but only prosecuting Bishop Whitehead on an impermissible basis would be selective prosecution. And he cites U.S. v. Armstrong. The government's unwillingness to answer the question of knowledge of Belmonte's criminal acts leads a reasonable person to believe that the government was aware of Belmonte's history. As the government has indicated, Belmonte is not subject to any cooperation agreement herein. Thus, Belmonte is certainly not immune from prosecution from any alleged crime in this district. I intend to reply to the government's opposition to Bishop Whitehead's 23.1H motion. However, if I am mistaking any position of the government on any matter, kindly let me know. So essentially, there was a very heated conversation because for you to follow up and memorialize it, if that's how the government felt that conversation with by saying threats, you were trying to make sure that you clarified that so that didn't get, so the court wouldn't think so, is what my assumption would be. This is like, I've never seen anything like this on the back and forth, and I'm not sure if the AUSA has ever seen this type of communication with another defense attorney, but hey, so essentially what they're saying is you're coming after Whitehead, but the person that you're using, which is what he said online, like this person or whatever. And honestly, I'm not saying that that person is like the best of people, but that doesn't mean that no crime can ever be committed against him. So you're kind of saying that because he's done that to people, basically he's done that to people, then what he shouldn't, you need to, I don't even get where this is going unless it was just for us to see that, but I already knew that about him. Like, I don't know the extent of Belmonte. I've heard things, people have sent me articles, people have sent me but they're saying they have recordings and other things in this case. So You said they didn't do this on Power. Where is my AKA Prosecutor 95? She a DA. I wonder what she would be thinking about these types of communications going on between him and the AUSA. So, of course, the AUSA did respond. They responded to that letter. And that must have been a heated conversation, boy. And they said, let me see. Let me see if I can find it. Their response was short and sweet. They didn't even say much to it, but uh, so as you see, their reply basically was, "Dear Judge Schofield," who's probably like, "I've never got this many filings like this on one case so early." The government writes with respect to the defendant's most recent filing. Earlier today, the government and one of the defendant's attorneys conferred at the defendant's request in an attempt to narrow issues before the court. Subsequent to that conversation, the defendant filed the letter, which purports to describe the parties' conversation and invites the government to state its disagreement with that description. The letter contains multiple inaccurate statements. Because, however, the letter does not seek any relief from the court or otherwise require judicial action, the government will not further address the matter absent direction from the court. Yep. So that was the government's reply to their response. That they ain't, that's not basically, that's not how our conversation went. That's all I'm gonna say. They're not requesting any legal remedies, so I don't even need to go any further and try to clarify. So I'm gonna go back and read some of your comments. And you guys, please go check out the first video. It's only about 15, 60 minutes, but I talked about little um miscellaneous topics before I got to this one because I knew it was gonna be long because of all of the documents involved. But this is what's going on in his case. Everybody always asks what's going on with his criminal indictment case, and this is the type of stuff that's going on. It's a lot of, we can go probably every other day doing some motion that has been filed and seeing what the response is. So Renee said the U.S. courts are not held to the same statutes like regular citizens are. Oh man, y'all. You said case closed, case over, plead guilty. I don't even know, honestly, like where are you going with this? Like, where are you going? Like, if you, it's almost like, well, he did it too. So if he did it too, when I got victims, I feel like how do you not know that they're not dealing with him as well? If you recall, when Whitehead's church was robbed, obviously they were still investigating him. At the same time, they need him because he was the person that got robbed, and they still went after the persons that allegedly committed the crime. So how do you not know who the government is looking at and what situations they have investigated or are investigating? They were doing it at the same time with your client. So how do you just assume that whoever you're speaking of, that they're not doing anything about? They don't tell us. They don't just say, "Hey, I'm investigating people right now," and put it out on the internet. Just like we didn't know he was going to be indicted for real until after he got indicted. But it still didn't stop them from prosecuting the people that robbed him. And he's probably their main witness. You're the victim one, and your wife is what, victim two in that indictment. But you still got indicted. So I think it's pretty presumptuous just to assume that the government just isn't and that's why I said I really wasn't going to read it at first, because I almost felt like you just wanted to let people know about who this person is. So maybe it'll change the narrative. But I mean, he has cases against him too. He has civil case. He's a business person. His father has some cases against him. So it's a history with him as well. Nobody's saying that there is, but does that negate, like, worry about what you did? You the one right now need to fight for yourself. You're being accused of some things. So worried about what they're alleging that you did. That's what I would be concerned about, making sure that I get free, worrying about somebody else. But anyways. That's what I like. Interesting. Very interesting. Now he has on, I guess he's a he does credit repair is his main thing, but since Whitehead, he's done the credit repair, he's done things with credit, he's done things with now we know real estate because of the building, we know the bankruptcy, and now the criminal. Now he's done the criminal. He's one of the attorneys. So it sounds like he's the one, according to the AUSA, he's been the main one communicating with them, and he's been the one signing a lot of these documents. He does have the other attorney that's a few of you guys inboxed me that represented Takashi 69. That she's on there as an attorney as well, and she actually primarily does criminal defense. Remember, at first, Whitehead was saying that he was his civil attorney, and that she was the criminal attorney. But he's entered an appearance as the criminal attorney, and he's filing these motions. So, do Daryl Brooks a sovereign citizen, Bishop White, be your own lawyer, sign up for your rights. Oh goodness. They hate Adam, so they're gonna get everyone close to him. Absolutely. That's starting to become abundantly clear. Somebody's getting indicted connected to him. At some point, can the judge cease the defendant from filing all these motions? The judge can do whatever he wants to do, or maybe set maybe dates where stuff should be filed. I don't know how. I don't know if they've ever dealt with this before. I don't profess to have seen everything, but typically when you do civil, it's a lot of paperwork, but you don't have this type of paperwork typically for criminal. Like, you file motions to suppress, you do certain hearings for experts, like you do certain hearings that you do, but for the most part, you're not just filing certain things back to back to back to back to back to back to back, like seems to be occurring in this case. But yeah. So anyway, that's someone he know from the rap game. I went to her page. She seemed like she has an extensive following because a few people sent me her Instagram. He might want to watch some old Matlock episodes and defend himself. It was be just as silly and cost less money. No, he actually has a criminal attorney on here. Because, like I said, the AUSA made it clear there's only one attorney that is, that I guess the conversation was with. So let me see the bottom of this. They say, in an effort to avoid further filings made solely to defeat attempts to equate silence with concession, the government notes that an absence of response on its part does not indicate agreement with any position or characterization advanced by the defendant. So basically, they're saying we're not going to respond. We're not even going to respond just to try to. We're just letting you know that we don't agree, or we don't agree with his characterization. This is like different. I've come to the conclusion that Adams must be as dirty as a Brooklyn sewer drain for them to be diligently taking down all his people one by one. They trying to pluck them one by one. I mean, it doesn't necessarily mean that. I think it just put the focus on these people. You know, it just put like, oh, you connected to them, like they going through old photographs or something. Like, oh, let me go check into their background and see what they're doing. St. James said, according to the evidence presented thus far, Pam, do you think you could get him off if you asked? What evidence has been presented? There hasn't really been any evidence except for what the government just let us know that there's supposed to be some recordings, I guess. I haven't really seen, we haven't seen any evidence. We just see allegations. Indictments are nothing but allegations. Now we've seen the stuff for the $90,000, Miss Anderson. We've seen that, but as far as Belmonte, we haven't really seen anything. We just seen what he alleged in his civil complaint, and then what's going on in the information, the little bit of information that's being let out in these motions. That's all we're really seeing. Thank you so much. If the court would go back and listen to audio of the robbery, his wife split the beans herself by her silent conversation with the robber. I don't know what you talking about, Jeff. What silent conversation with the robber? Well, today, if you didn't see, look at my other video where I talked about XXXTentacion, and they're blaming Drake, and who was the other person? They're saying Drake had something to do with it, they being one of the defendants. And I tried to write their names down because I don't know any of these people. All these trials keep reminding me that I am getting old. I'm like, who are these people? But when they did the hip hop stuff on the Grammys, I knew all those rappers. I knew all those raps. No, but I didn't know any of the new school that came on after that. So Dedrick, is it Dedrick? What? No. Which one said? Yeah, Dedrick Williams' attorney basically was saying on the X case, was saying that essentially because he was such a famous entertainer, being, unalive in that area, that the prosecutor rushed to judgment. And so they said, well, he mentioned, he being XXXTentacion, he mentioned that before he died, he said if anyone unlives him, it's Drake. But the police never talked to him or asked him. And then before, I guess, he was unalive, Antonio King, also known as 600 Breezy, posted on YouTube, when I get off of probation, then basically he threatened him on YouTube and said that the government didn't do anything about that, even though he was threatened. So they always gonna blame another rapper. That's the moral of the story. Will we see evidence this early or later? We probably won't even see the evidence till the trial, because I'm sure it's going to be plenty of us in that courtroom if he has one. We're gonna take up an offering for every people to fly to New York and go watch this joint. He said the robber held a gun to his daughter, but the robber also asked which item of jewelry did she want him to take. Oh, really? I didn't know that. That's the first time I heard that. Yeah, it's Jamila something. She talked about her fraud case, and at the end, she talks about getting her real estate license, and it shows her standing with them. Real estate. Chat queen. It all seems like a house of cards collapse is inevitable. Yep. But anyway, thank you guys for hanging out with me, and thank you again for all of the birthday love. I hit the wrong button. Thank you again for all of the birthday love. We really appreciate it here. I got to take a couple of more days off and just rest because of all the love that you guys have bestowed upon me. And I'm going to hop off of here. Let's see. You know what? You guys are funny. So that is our latest Whitehead update. I'm sure that it will be more because we have several cases that we are following. And as soon as I get the documents, I'm going to bring them to you first. Nobody brings the documents like we bring them over here. If you guys have not done so already, please subscribe and please like. Thank you for all of the shares on Twitter. I had a lot of people say, I saw your content on Twitter, which is pretty dope. Thank you guys for that. I so appreciate it. And you all enjoy the rest of your night. And I will holler at you next time.